Yes, Lord King.
My Lord, could I begin by picking up on one or two points that arose this morning? First of all, there was the question of the time taken for out-of-country appeals, and I would confirm that the average time on current data is 20 weeks from the notice of appeal, and as my Lord observed, that notice of appeal would have to be lodged out of country. The second matter concerns the amendment...
Can we compare 20 weeks out of country with the length of an in-country appeal?
Not immediately, my Lord, but I shall endeavour to ensure that we can before the conclusion of this hearing.
Machinery is available, perhaps.
If it's not obtained this afternoon, my Lord, we will write.
Thank you very much.
My Lord, the second point concerns the amendment to the guidance, and I'm reminded that at paragraph 12 of the Court of Appeal judgment, it was noted that we had undertaken to amend the guidance in light of the Court of Appeal decision. And the Court of Appeal judgment was 13th October 2015, and the amended guidance was issued on 30th October 2015.
Sorry, 15.
2015, my Lord, yes.
Yes, that's what you've passed up that in version 6.
I didn't. I believe my learned friend Mr. Gill arranged to pass that up, but
Thank you.
I'm obliged.
This is version 5, that was the 13th
It is,
October, yes.
lady,
And
it
there's
is.
a version 6 from May of last year.
And now 7.
And now 7, yes. Because that's what we've got.
The Secretary of State's extremely proactive in these matters. The third matter concerned a point raised by my Lord Toulson, which was with regard to the prison visit records. And I apologise that confusion arose over that. I accept that they were enclosed with a letter in 2014. The reason that confusion has arisen is because the material before the decision maker on 3rd September 2015 is listed, and it doesn't include a reference to the prison records.
Makes one think the decision maker, for one reason or another, simply didn't have them in mind.
That is a very reasonable inference to draw, my Lord, and I don't take issue with it at all. But I should perhaps just elaborate a little on that point. If your Lordships go to the decision letter of 3rd September 2015, they will find it in Appendix Part 3, page 421, MS 7287.
So this is the supplemental one.
This is the supplemental one, my Lord. And if they go to 422 or 7288 on the electronic, at the foot of the page, there's a heading, in support of your Article 8 claim, you submitted the following evidence. And it doesn't include a reference to the prison visit records. However, it has to be borne in mind that the decision maker did accept that there was a parental relationship, that there was a genuine, I should say, that there was family life. I said parental relationship. The decision maker did accept that there was family life, and that's apparent from the decision as a whole, but more particularly from the point made at page 438. Put at the page 18 of 21 of the letter, Article 8 conclusion, where it was said that the public interest in deporting you outweighs your right to private and family life.
I wonder if that's doing anything more than parroting the wording of Article 8.
Well,
it's not making a conclusion about whether he has a family life.
Well, with respect, my Lord, I won't read the entire letter,
No, but if
I
do read it, I'll find
I
it.
invite your Lordship to do so, because it becomes clear.
Yeah.
And perhaps there's a point in particular that I should bring out in light of my Lord's observation. What is being addressed, if my Lord goes to page 3 of 21, that's at 423, or MS 7289.
Yes.
Two-thirds of the way down the page is whether or not there is, and I quote, a genuine and subsisting parental relationship with those children.
Yes, and the conclusion on the next page, 2/3 of the way down, is that there is not.
Indeed so. And that is the term that is used throughout. It's not whether or not there is a family life.
No.
It is whether or not there is a genuine and subsisting parental relationship. And I should point out that that is a term of art, which is taken from the immigration rules at paragraphs 398 to 399A. Those immigration rules are, of course, subject to parliamentary approval. And that is borne out if we look at the relevant guidance, which is in the authorities volume 2, at tab 30. MS 570, which is headed Immigration Directorate Instructions, Chapter 13, Criminality Guidance in Article 8 ECHR Cases. And if your lordships go to section 221, MS 575,
Yeah, we see the phrase at the top of the page.
Indeed, and it's taken from the reference to the immigration rules, genuine and subsisting relationship with a qualifying child. And that is elaborated upon if you go to section 3(3) at MS 583. And the point is made there under the heading genuine and subsisting parental relationship. Having family life with a child does not necessarily mean the person has a genuine and subsisting parental relationship with the child. A parental relationship is a particular type of family life. It is possible to have family life with a child without having a parental relationship with the child. The following is a non-exhaustive list of relevant factors to consider when assessing whether a foreign criminal has a genuine and subsisting parental relationship with the child. And then there's a series of factors that are brought in there.
I don't want to take up undue time on this, but can I just ask you to go back, please, to MS 7290 or internal 424, which is in the supplementary decision letter. Halfway down that page, do you see the paragraph which starts?
I'm sorry, my lord, internal
424.
Yes, my lord.
Halfway down that page, do you have the paragraph which starts, you wrote to the Home Office?
Indeed, yes.
Well, then, if you read through that paragraph to yourself, effectively saying no contact with certain named children while he was in prison, whereas when you actually look at the prison records, you see that they were visiting him every month. Two paragraphs down, for all of these reasons, it's not accepted you have a genuine and subsisting parental relationship.
Indeed. And that's why I say, my lord, it would appear that the prison records were not before the decision maker.
But more than that, the positive point was being made that there had been no contact with the children while he was in prison, which was actually positively wrong. And that provided part of the foundation of a conclusion that there was no genuine and subsisting relationship.
It was certainly said that there was no evidence had been provided. I think if my lord looks at the last sentence of the previous paragraph, it says in terms, no evidence has been provided to demonstrate the children visited you in prison. Yeah. And I accept that on the face of it, such evidence had been provided, my lord, but wasn't before the decision maker when this decision letter was formulated and sent out. Yeah. However, the test was not whether or not there was family life. That was acknowledged. The test was a more discrete one of genuine and subsisting parental relationship as defined at section 3(3) of the guidance. And on the face of it, that would not have altered on the basis of prison visits.
What? That surprises me.
Well, just looking at the criteria that are set out, milady, I'm not seeking to excuse the omission in any sense, and clearly it's a matter that would have to be addressed in due course as regards the decision-making process. But it is not, on the face of it, determinative of the issue of genuine and subsisting parental relationship.
No, but even if we're using standard judicial review criteria, if you accept that information was before you and you didn't have regard to it, and it's a material consideration, then it seems to me that it calls the decision into question.
Well, there is an issue there, my lord. I candidly accept that. On the face of our examination of this document, it did not appear that the prison visit records were available to the decision maker. And I say that without qualification on the basis of what's now before me.
Yeah.
However, looking to the criteria under genuine and subsisting parental relationship, it's not clear that the relevance of the prison visits would have had a material bearing upon the determination of genuine and subsisting parental relationship as defined by reference to the immigration rules and as set out in the guidance in the
the list at 583.
Exactly the same, my lord. But as I said before, I apologise for the confusion that arose. We were relying upon the list within the decision letter itself and had not appreciated that the material had been made available but not submitted or available to the decision maker. I'm advised that if that material had been before the decision maker, she would have listed it as she did the other material at the foot of page 2 of the decision letter. My lords, can I turn back just to touch briefly, and indeed I hope lightly, upon some of the points made by my learned friend Mr. Fordham earlier this morning. He began with 3 reference points and then went on to develop a further 4 points. And if I can just take your lordships back to the reference points. The first was the matter of evidence submitted by BID. We are not able to verify the detail, for example, of the case histories that are referred to by BID, but we have no reason to ignore the evidence from BID, and we don't consider the court has any reason to ignore the evidence from BID. It expresses a particular view with regard to the matter of these appeals. And indeed, I have to add that we actually rely upon some of the evidence adduced by BID, and in particular, the correspondence which was adduced from Tribunal Judge Peart with regard to the use and what appears to be the extensive use of Skype in the context of out-of-country appeals. The second reference point referred to by my learned friend involved reference to Lord Bingham's observations in Huang. Of course, in all Article 8 cases involving removal, there are important rights at stake. Nobody would shrink from that. And it doesn't appear to me, however, that these references advance matters in any material way. Here, what are the critical issues? Well, they are the critical issues that arise in the context of criminal deportation. And the court addressed them in the context of Hesham Ali. On the one hand, the public interest that has to be considered and is expressed by Parliament in these various statutory provisions. And on the other hand, of course, the interests of the individual who has a family life or an established family life in the United Kingdom. What I would add is that these rarely involve hard-edged issues of fact that have to be determined by a tribunal. The critical facts, such as criminal history, period of incarceration, residence, parental relationship even, are generally not disputed facts. Prison records should not be disputed. social work reports from an independent social worker are available for consideration and scrutiny. So there are rarely hard-edged issues of fact. And in that context, I do take issue with the suggestion in the witness statement from Mr. Sharma that the Home Office never agrees any facts. And indeed, my learned friend, Mr. Drabble, referred to that and then seemed to move away from the statement himself as being entirely accurate. Clearly, the issue of what inferences should be drawn from the primary facts may be a matter of dispute. But in my respectful submission, there's no evidence that the Home Office never agrees the facts. That simply isn't right. There's then the third point of resources, and the point made that there's been no change to resources for out-of-country appeals. Well, again, I just remind your lordships, first of all, of the correspondence between BID and Tribunal Judge Peart on the matter of how out-of-country appeals are conducted. And Mr. Tribunal Judge Peart correctly identified the role of the tribunal, and my observation would be this. If the tribunal did suffer from insufficient resources to actually discharge its duties, then one would expect them to say so. And the one thing Tribunal Judge Peart does not say is, we simply don't have the means to conduct these appeals. And in the context of Skype, I don't want to elaborate too much, but what is required are 2 telephones or 2 laptops and a Wi-Fi link. Now, you can elaborate upon it if you wish, but I'm sure we all have current experience of how Skype actually works on a day-to-day basis. It may be that 5 years ago, the issue of video links had to be addressed in a rather complex way, as it was in the guidance set out in NAIR. But that is not the case now.
Well, the mere contact isn't the case, but Advocate General, as you know, when one was looking at video links in the context of taking evidence in criminal trials, you had to ensure that the witness was in a room by himself or herself, or only in the company of a trusted individual who would not interfere with what he or she was doing. And it wasn't simply having a laptop or an iPad on your kitchen table. The participation of the individual in the forensic process had to be controlled.
Of course, my lord, but one has to, again, contextualize this. In what circumstances is it going to be necessary to take oral evidence from an appellant in the context of a deportation appeal? Yes, in the context of him wishing to speak directly to his relationship with his children, in the context of him wishing to speak to his rehabilitation or his intended rehabilitation, these are not the same sort of critical cutting-edge issues that one has to address in the context of a criminal trial for evidence beyond reasonable doubt. This is in order to give the tribunal an impression of the genuineness of the appellant in circumstances where the tribunal has itself already concluded that that will be necessary for a fair decision-making process.
But I mean, we know that the tribunal does already use Skype evidence. We don't know anything about how that's regulated.
Well,
presumably,
Tribunal Judge Peart is quite clear about it. They seem to be entirely comfortable with the process.
They expect the parties to provide their own.
Indeed, but they appear to be entirely comfortable with the manner in which the process is carried on, and they allude to the fact that there are, as they list, numbers of firms of solicitors and chambers that are in habit of actually dealing with this.
Yes, but is it realistic to expect a deportee sent to Kenya or Jamaica to arrange the Skype, provide the equipment, ensure that that it is compatible with whatever system the particular tribunal has?
In my respectful submission, there's on the face of it not materially more onerous than expecting them to arrange either witness statements or bundles of evidence or to attend an oral hearing in this country.
Is NER the last word from the tribunals on electronic evidence?
It appears to be the last word on video link evidence, as
Right.
far as I'm aware. Of course, there is a guidance note as well,
Yes, we got that. That's at,
which you already have,
yeah, we
which I
got
think is
that.
dated 2013, but I say that
Indeed,
from
which
recollection.
was why what prompted the question. Sorry, is there anything since then on Skype? Because as you say, technology has marched on.
Yes, the letter from tribunal
Yes,
judge
but
appeared.
but yes, he says we're using it, but presumably one would expect there to be some guidance or directions.
There is, I apologise, my lord, I was misunderstanding. If you go to Tribunal Judge Peart's letter,
Right.
and then turn back to the bid letter, and then just before that,
Yeah.
you will see the guidance from the tribunal, which was what prompted the bid letter to the tribunal.
Thank you. Which page number?
6840.
Yes, the directions.
Skype directions.
Thank you very much. Yeah, thank you.
So this is directions in a specific case. It's not sort of general guidance as the sort we had in Neri.
Well, it's addressed to Liberty, but it appears to have prompted bid.
No.
Sorry, I apologise.
It's addressed to bid.
I apologise.
It's using the word liberty in a rather old-fashioned sense.
I've picked that up wrongly. And I'm reminded that Tribunal Judge Peart actually says in his letter, which is a few pages further on, that it is addressed on a case-by-case basis.
But you'll see that it includes a requirement for projection equipment and audio equipment, as well as just the computer and the Wi-Fi link.
On a case-by-case
Most
basis.
Skyping is done,
Yes.
as you have pointed out,
Yes.
on an individual.
And if circumstances arose, my lady, where it was clearly not possible for the appellant to engage with the tribunal on that basis, and the tribunal was clearly of the view that it required oral evidence from the appellant before it could make a fair determination in the case, then the tribunal would say so.
Yeah, but that's too late, isn't it? The whole point about this, we're dealing whether the Secretary of State could be satisfied that Section 6 is not breached. And if it all depends on... I mean, you're just assuming that we work on the presumption that whatever is necessary will be done by the tribunal in due course, and that it will have the resources to ensure that happens.
In the generality of cases, it is not, we would submit, appropriate to assert that an in-country appeal will be required and that oral evidence will be required.
I understand.
In exceptional cases where an out-of-country appeal has been certified and the tribunal concludes that it must have oral evidence for a fair disposal, then it has the means to require that, either by allowing Skype, or if that is not practicable, to call upon the Secretary of State to consider how it can fairly dispose of the appeal, given the outstanding certification that's been given pursuant to 94B.
Yes, I mean, your case has to be, I mean, we're familiar with these procedures with entry clearance. Although we're dealing with something quite different here, it's nonetheless a very narrow area of inquiry, because what we're asking ourselves is, given the strong presumption of deportation of foreign criminals, are there any exceptional circumstances, or no, very compelling circumstances, as we now put it. So it's a relatively narrow inquiry, which, although completely different from the entry clearance, is nonetheless no more likely to require oral evidence. Is that the sort of way you put it?
Indeed. But if there was an exceptional case, then that would be taken into consideration at the stage of considering certification.
if there was certification and then difficulties arose, in my respectful submission, the tribunal has the means to ensure a fair outcome for the appeal.
You mean, we were wondering what you meant about an exceptional case. You mean, if there was an exceptional case requiring the appellant to give live evidence, then? So you say...
That would be a ground for not certifying pursuant to Section 94B, my lord.
You say live evidence is only likely to be necessary in exceptional cases.
Indeed.
Yes, we have that point.
Yes, I'm obliged. Turning to the 4 points that my learned friend Mr. Fordham then continued with, he referred to the Court of Appeal at paragraph 71, talking about a generalisation and saying that that was not apt. But with respect, reading the judgment as a whole, and I simply invite your lordships to do this in due course, the Court of Appeal was responding to a submission by the appellant that it was generally unfair to have an out-of-country appeal. And that's the point they were addressing there. The second of the 4 points made by my learned friend was the point about duty of inquiry, the Secretary of State's duty of proactive inquiry, as he put it. Well, with great respect to my learned friend, that's precisely what the Secretary of State undertakes. That is why, when notice is given, a very detailed and lengthy questionnaire is submitted to the relevant party.
Now, it's obviously directly related to the guidance on criminality that we were looking at, because the questions asked mirror the questions in the paragraph 3.
In the guidance.
Yes.
So a party with the guidance and the questionnaire is being invited to provide very detailed material pertaining to any Article 8 claim that he wishes to make. The third, and I should add that my learned friend also referred to SS Nigeria, but again, it simply vouches the same point. And the Secretary of State, as I say, is responding to an obligation by making inquiry using the questionnaire. The third point my learned friend raised concerned the issue of judicial review. And the proposition that really the question was one for the court, not for the Secretary of State. But with great respect, Section 94B is perfectly clear. Parliament has decided that the decision is expressly for the Secretary of State, not for the court. And judicial review on orthodox human rights grounds is then available in respect of that administrative decision. And that will involve anxious scrutiny of material before the decision maker. But Section 6 of the Human Rights Act is always the issue.
I think you accepted towards the beginning of your submission that if in the context of a strict scrutiny through judicial review, the court came to the view that the removal would be contrary to Section 6, then it would have to act on that regardless of the limits of the judicial review power, in effect. You were accepting, you were saying they didn't have to do primary fact-finding, and they shouldn't do that. But if they came to the view that there was a breach of Section 6, then they would have to act on their own assessment.
I don't say that that would be regardless of the judicial review power.
No, regardless is the wrong word. But it wouldn't just be a question of the rationality of the Secretary of State's decision.
No, because if the Secretary of State had made a decision that was plainly perverse because she refused to address a series of material facts, for example, the court could address that.
But what if it wasn't perverse, but the court reached a different view on Section 6? What then?
Well, the decision maker is the Secretary of State. That is what Parliament has provided. If the court concludes that in making that decision the Secretary of State has acted in breach of Section 6, then so be it. But that is addressed in the context of review of the administrative decision. That is the scope of judicial review in all human rights cases, not just criminal deportation cases.
But to decide that the Secretary of State has acted in breach of Section 6 is to decide for oneself.
That the Secretary of State has acted perversely, or
No, in breach of Section 6. That is the judge deciding it for himself.
well, with respect, my lord, it appears to me that clearly under 94B, the decision, the primary decision, is for the Secretary of State.
I mean, you're having to say that the normal question, which is for the court to decide whether there's a breach of Section 6, is implicitly displaced by Section 94B or modified by 94B.
It's not making, the court's not making the primary decision, is the way I would put it. The court is reviewing, with anxious scrutiny, the decision made by the Secretary of State, the decision that's been given by Parliament to the Secretary of State. It would be different if the court had been given the primary role by Parliament, if Parliament had said it will be for the court to decide.
But the closest analogy amongst the decisions of this court are probably the Lord Carlisle case, where again the Home Secretary was given the power to say that the presence of a particular person in this country was not conducive to the public good. That was very much the Home Secretary's power. The court then reviewed that decision in judicial review proceedings and held, firstly, that it could have challenged the facts that were the evidence that was produced by the Home Secretary. It wasn't challenged, and therefore we had to take the evidence produced by the Home Secretary more or less at face value. But secondly, the question of proportionality was definitely for the court. But I say, the court held that they could have challenged the facts.
Well, that brings me on to the further point made by my learned friend, where he, under reference to the case of H, he wanted to make the point that proportionality is for the court. Well, we fully accept that. That was our position before the Court of Appeal. That is our position before this court. The issue of proportionality is for this court. Finally, my learned friend referred briefly to authorities, including De Souza, Ribeiro, and Khalifa. And he sought to make the point that in neither of those cases did the Grand Chamber have to grapple with whether or not an out-of-country appeal was effective. But what the cases do show is that an appeal does not have to be in-country in order to be compliant with the procedural requirements of Article 8. And that is the point that we take from them in this context. Lady and my lords, those are all of the observations I would have to make with regard to the submissions made by my learned friend, Mr. Fordham. And in these circumstances, I would renew my motion to the court to refuse these appeals. Unless there's anything further I can assist the court with, I would rest my submissions there.
Thank you very much, Lord Keane.
I'm obliged.
Ms. Giovanetti? Now, how have you decided to divide up your reply time?
I think I'm first, if that's acceptable.
I'm sure we regard it as a matter between you and Mr. Gill, as long as you don't go over the combined hour that you have.
We won't. Well, for my part, I won't go over my half hour. First of all, just some very basic observations about Section 94B and my learned friend's submissions on the statutory code, as it were. In my submission, a helpful way of looking at Section 94B2 is that it is a piece of what I might call safety-first drafting. There is a relationship between Section 94B2 and 3, but what Parliament has done in 94B2 is guarantee that the end result won't be a breach of the Human Rights Act or our international obligations. It's not necessary for me to say that Parliament foresaw the exact shape of an argument about Article 8 at the time of enacting it, although maybe it did. But we do know that Parliament placed an imperative obligation on the Secretary of State to ensure that the certificate did not lead to a breach of Section 6. And accordingly, my learned friend's submissions about Parliament having decreed that deportation of criminals was international criminals foreign criminals was in the public interest is subject always to the proviso that Parliament also laid down a mandatory requirement that the immediate deportation pending appeal would not be a breach of convention rights. A particular breach that it foresaw, possibly wrongly in terms of the approach to serious irreversible harm, was the matter set out in 94B3. But we know for sure that the one requirement it did lay down was the 94B2 requirement, no breach of Section 6. And accordingly, a ruling that says you can only certify where you are satisfied in the individual case that there will not be such a breach is giving effect to the will of Parliament just as much as removal of a foreign criminal would be on different policy grounds. Second background observation is that it's commonplace of procedural protection cases, and indeed it lies behind our sliding scale approach, that the more serious the allegation, the more serious the consequence, but in particular the more serious the allegation, the more important it is to provide appropriate procedural protection. And so it's not an answer to our case based upon the procedural contents of Article 8 to say Parliament has decreed that the removal of foreign criminals is in the public interest. That may be so, but because of the force of that demand, the more important it is to provide appropriate procedural obligations. So those are the two background observations I wish to make at this point. Can I then move on to a separate topic, which is to deal with Lord Calmer's observations about what happened in the Court of Appeal or what could have happened in the Court of Appeal. As we know from paragraph 12 of the Court of Appeal judgment that we were looking at just a moment ago, at the moment of the Court of Appeal hearing, the guidance was extant. And certainly the argument that was put forward on behalf of Mr. Kiarie was on the basis that the decision in the individual case was flawed because it was based on guidance or infected by the same error of law contained in the guidance that was wrong.
Yes, your certificate was given when?
Well, it's certainly given given before the change in the guidance.
Yes.
It was given, I mean, there were two, I mean, if one going to get into the detail of my certificate, it was given on the basis of the original form of the guidance and in circumstances where no questions were asked.
And we're dealing with a legal act, namely a certificate.
Yes.
It has certain consequences.
Yes.
And you want that to be quashed.
Exactly.
So, we're not dealing with quashing reasons, we're dealing with a particular legal act.
Yeah, exactly.
And that act was dated some time way before this,
Yes.
and was, you say, and everyone agrees, was flawed.
Yes, absolutely.
So
That
prima facie, you would say you're entitled to succeed.
And that goes on to my answer to your Lordship's questions about what the Court of Appeal should have done and its relationship with the upper tribunal. The way that we presented the case in the Court of Appeal was indeed that the Court of Appeal should retain the judicial review. There was no problem about that. But that the remedy would be quashing this, would be quashing the certificate and leaving the matter back to the Secretary of State, or alternatively remitting it to the upper tribunal. What instead happened was that the natural consequence of the identification of an error of law was not remission anywhere, but the Court of Appeal was substituting its own view on the effectiveness of out-of-country appeals as a generality. It's that step, is in my submission, where it all went wrong, because
Of course, this was before we had the Karupan decision, as
Yes.
it's called. Do you want to say anything about that? Because that in a way underlines the potential problems in these sort of cases. And,
Well, I'm not going to. Mr. Gill may have something to say about that, but I'm not going to. All I'm anxious to do is to identify the fact that it's not the retention of the judicial review by the Court of Appeal that's the problem, because it turned out that there was indeed an error of law in the
what they did afterwards.
in the certificate. It's what happened afterwards. Yeah. And in my submission, it may be partly because the initial focus in the Court of Appeal proceedings was on the legality or otherwise of the guidance and the relationship between subsection 2 and subsection 3. That the Court of Appeal did not think out as well as it might have done what was the procedural consequences of the issue of the certificate. We say that certainly now we've got here, although this does echo submissions I made to the Court of Appeal, when one considers commonplace examples, it's obvious that the Secretary of State can't, under the present administrative arrangements for disposal of out-of-country appeals, certify in the generality of cases in the way the Court of Appeal said it should. And the example I return to, and it is an example that I put to the Court of Appeal, is the example we have at paragraph 7D of our printed case. It's memory stick number 6587, if the court wants to turn it up, but I mean, we're familiar with it. It's, the example is...
Wait, paragraph again?
It's paragraph 7D, but it's at the foot of page 6587 in the core volume.
Oh, yeah.
But it's a commonplace example. You assume that on the basis the certificate has been issued, on the basis that the appellant is out of country, the UK appellate scheme envisages that there will be an oral hearing. My learned friend doesn't dispute that. So on the face of it, there's a hearing at which evidence is going to be given. There's a hearing at which something will happen. That's almost the only submission I need to make. If the appellant's family are present and give evidence, then they will be cross-examined. Similarly, the same will be the case of the presence of any expert or any other member of the community or whatever who gave evidence on the appellant's behalf. The appellant will not be there, and he will not be able to give instructions or react to developments during the course of the hearing. This is blindingly obvious, unless some exceptional step has been taken to set up an electronic link. And essentially what we say in paragraph 7D is that the Secretary of State has to accept that is going to be a commonplace position, and therefore say that's acceptable in terms of the procedural protection under Article 8. And we say it simply isn't.
How does that affect your client, though, who doesn't have children? Your client's case, you'll come on to that.
Yes, I'm not going to come into a great deal of detail, but I mean, there is evidence from him and his mother on the various limbs in the under the Maslow criteria and so on. But he certainly will be calling his mother.
But I mean, it's a relatively straightforward case. There's an issue about whether he has ties in Kenya.
Yes.
But apart from that, it's difficult to see that there are any sort of exceptional or very compelling circumstances within the principles of Hesham Ali.
I don't accept. I will come to that. I don't accept that's right. Can I just develop this part of it, and then I'll come back. It's the very next chapter, as it were, in the reply. But you've got same in my client's case. His mother would say, if she gives evidence in accordance with the witness statement, that he's an immature man who's never lived away from home, is integrated into his local community and so on. She will be cross-examined about that. Now, if she comes up with something disadvantageous to his client, he won't even know that it's been said. It's just not an acceptable procedural situation.
What is the area on which he is likely to have to give evidence? I mean, there's no real dispute about the nature of his relationship with his family.
Well, your Lordship says that.
There is a question mark as to whether he has any contact with kith and kin in Kenya and how he would cope in Kenya. Is that going to be advanced by him giving oral evidence in support of his witness statement?
Well, the answer is yes or no, depending on the outcome of the live proceedings. That's the nature of a hearing at which oral evidence is given.
What I'm really feeling for is this. One can see in some cases that you look at the Secretary of State's decision letter, you look at the appellant's case, and you can see that there's a complete area there which calls out for exploration through cross-examination. Is there an equivalent in your client's case?
Well, yes, the Secretary of State decision letter has a series of adverse comments about the extent of my client's integration into the United Kingdom, about which he would undoubtedly give evidence.
Yeah.
I mean, let me just run through the factors. In a case of this sort, and applying Hesham-Ali, you will need to consider first integration into two different societies, both in the UK and in the United Kingdom. You will need to consider the strength of the family links, the nature of the relationship, and there are again adverse comments about the strength of those family links in the Secretary of State's decision letter. You will need to consider prospects of employment, which you will give evidence about. You will need to consider rehabilitation and risk evidence. And one would expect evidence to be given in relation to all of those aspects. And that's not a comprehensive list. That's just the nature of this sort of exercise. And so my client would succeed, first of all, on the basis, under the rules, if he succeeds in showing that there were very significant obstacles to his integration into Kenya. Can I just correct one thing? I gave the court the wrong reference to the rules yesterday because I dealt with it by looking at the rule as set out in Hesham-Ali. There is, in fact, a later version of the rule, which is the correct version, and the difference is in Rule 399A, little c, which has changed from a rule which requires no ties with Kenya to a rule which requires very significant obstacles to his integration in Kenya. Your Lordships and my lady needn't go to it, but just to give you the reference, it's Authorities Bundle 3, tab 37, at page 710. So the rule has changed, but there will be a straightforward issue about whether he and his mother are correct to say there will be very significant obstacles to his integration.
Yeah, I mean, in a sense, that change helps you in the sense that whether you have ties is quite a short point, whereas whether you are into how serious the obstacles are is obviously a judgment.
My submission is that, not shy away from it, in no other system of adversary hearings would you contemplate a situation in which fact-finding of this sort, whether it's primary fact-finding or the nuances of inferences to be drawn, took place in the absence of the main party and without a legal representative of the main party. But that is precisely what the Secretary...
Entry clearance appeals we're quite used to. And although they're different, they may involve these sort of issues.
Well, your Lordship says we've set out the differences between entry clearance and this sort of case in the evidence. And I took your Lordships and my lady to it yesterday. There are significant differences. And I'm certainly not saying you can't imagine a case where in an entry clearance case the presence of the person from abroad was necessary. It is unlikely because the focus is going to be on material in the hands of the on the position of the sponsor in the UK and material generated in the country from which the applicant is going to come. But in any event, whatever be the position in entry clearance, you have to contemplate a situation in which someone is setting out to prove either that they qualify under the rule on the basis of significant obstacles to his integration and gives and wishes to give evidence on that, which, if believed, will make the case good. Or alternatively, is proving a Hesham-Ali very compelling circumstance case by a series of different components. It's the binary approach is to say, well, you only look at one element. But the truth is, that you may well have a very compelling case composed of very considerable length of residence in the United Kingdom, very close family ties or particular effects on a relative, realistic evidence of low risk, if that be the case, decent prospects of employment and so on. They can add cumulatively to a very compelling case. It doesn't need to be just one element or another. And as I repeat the submission, that it's inconceivable that in another area you would allow that process of evaluation to take place, first of all, without receiving the oral evidence of the appellant themselves directly, and secondly, without the appellant being there. And it is a quite startling proposition. And I mean, we say that the court should simply not write a judgment which says that that's an acceptable position. If your lordship and my lady wish to look at the sort of case which my client's mother was putting forward, you will find her witness statement at Appendix 3, paper page 786, memory stick 7652, talking about the difficulties that she says he would face about going to Kenya. She will be cross-examined on that, no doubt, in the absence of my client. So we do submit that it is a mistake to view, even in Hesham Ali case, well, I say even in Hesham Ali, this is a Hesham Ali case. In a Hesham Ali case, the need for a very compelling case to mean that you don't examine each of the potential Maslow criteria one by one in order to look up, to evaluate the strength of each of the appellant's case under each of the criteria. You may end up at the end of the day with a very compelling case. And what the procedural position that's emerging is doing is denying the appellant the ability to put forward such a case. So, I repeat, the fundamental mistake would be to reject the possibility of that emerging without it being tested in the tribunal proceeding. If my client is not here, that is precisely what is happening. What the Secretary of State is inviting the court to do is to read the witness statements in advance and to say, well, there's no prospect on that basis of a case emerging that meets the Hesham Ali criteria. And that is a recent bit unacceptable. So if one tries to think through what would actually happen in practice, if my lady and my lords go to the evidence that was put in front of the Court of Appeal, the agreed statement on procedure, your lordship and my lady will find Appendix 3, page 395, at 395, I'm sorry. Appendix 2, page 395. And that's memory stick 7264. And the point of this submission is to try to work out how all of this will actually work in practice. So if you look at internal page 398 to Appendix 2, MS 7264, as I think I already said, you'll find a heading Case Management. We'll try to work out what the Secretary of State says would happen on his model in a certified case. We have the case management directions. You will see that they require the standard directions that 5 days before the full hearing, the appellant will serve on the tribunal and the respondent the witness statement, the paginated bundle, skeleton, chronology, and so on. And similarly, the reverse, from the respondent. Now, my instructions are that that bundle and those witness statements will find their way to the tribunal judge either the day before or the day of the hearing. There won't be an allocated judge before that. They will obviously find their way to the respondent, hopefully 5 days before. That is, my client's witness statements will find their way to the respondent at that point in time. Now, what is the tribunal supposed to do? Is it, I think my learned friend's case is that it embarks upon the hearing, and if during the hearing it thinks, well, we're not going to take these witness statements at face value, we need live evidence, then at that point something else happens. Completely unclear what it is that happens. Wouldn't have had a chance to think about it before then, because it won't have had the bundle before then. Similarly, what does the Secretary of State do, one asks rhetorically? Secretary of State is presented with a witness statement from an out-of-country appellant who says, I am having a terrible time in Kenya. I am finding it impossible to integrate. What does the Secretary of State do? He can't cross-examine. Does he just accept the statement at face value? Does he then, at that point, say, well, hang on, I now realise I'm going to need a video link or some Skype link or something of that sort? My submission, if one tries to think through the practicalities in the present administrative arrangements, it demonstrates that the model of, which is predicated on the basis that in most cases you do not need live evidence, simply can't be made to work. If the tribunal does decide, well, if it is a case, let's not talk about the tribunal's decision, if it is a case in which some other form of link is necessary, then one has to examine the actual real availability of means of dealing with the problem. If the court will stay with, well, now go to Appendix 3, at page 1034 and 1035, we have the material that was in front of the Court of Appeal. Emanating from HMCTS, the court service.
Ah. Could I have an MS number?
Yeah, 1034. Oh, so,
No, it's not that.
yeah, sorry, I have actually got that written down. Let me just catch up with myself. 7,900, 7900.
Thank you.
Is, I think, the start of, no, that is, I think that is 1034 and 1035.
It is.
And if you look at the foot of page 1034, i.e. the foot of 7900, as I anticipate, you will see that the question HMCTS are addressing at this part of the material is the extent to which video link is available within the HMCTS estate, whether that can be linked into from overseas, and if so, how, if not, what the difficulties are. And then the answer is hearings conducted by video link are available across UK hearing centres. However, one, the lack of compatibility with overseas equipment, access to suitable overseas facilities, cooperation on some occasions with overseas authorities mean that its use is not widespread. Resources are limited and primary use of video link equipment must be reserved to UK detained appellants. This means that HMCTS could be faced with a resource issue unless there's substantial investment. And then the court can read the other points there. Then going on, there's a difficulty about international timing pointed out at F, but then most significantly for present purposes is the answer at 9 in the middle of August 2015. The question is asked, what other options are there, Skype, web chat or telephone? And the answer is HMCTS is not yet in a position in terms of IT security and facilities to use Skype and web chat. Telephone hearings are still available, but are very rarely used. The upper tribunal has stated in past decisions that video link is preferable over telephone. Now, of course, I'm aware of Judge Peart's answer in the email exchange with Beard. We have no information at all about how many examples of the use of Skype are, no evidence at all of any use of Skype that hasn't been prompted by a highly diligent lawyer and representative based in the UK making the arrangements abroad. Simply no basis on which it can be said. Judge Peart also doesn't actually talk expressly about out-of-country appeal. We simply know nothing about what that's a reference to. We do have an express statement from HMCTS that it's not in a position in terms of IT security and facilities to use Skype. Those two headings, descriptions, IT security and facilities, are important.
So which page are we on now?
We are on internal page 1035 in Appendix 3.
Thank you.
You're running out of time, Mr. Drabble.
Sorry, I am indeed. Yep.
Is this, and this is an HMCTS document,
Yes.
is it then annexed to the upper tribunal judiciary
It is.
document?
Well, it came from HMCTS together with the upper tribunal
I see.
document,
Very well.
which was objected to and disregarded by the Court of Appeal. Your Lordship may have picked that up. But I just rely on the practical answer that G. And I'm running out of time, so I'll keep on going. Can I then, very limited number of other points, can I take the court to what actually happened in Nare, Authorities Bundle 11, page 128.
Tab.
It's tab 128, my fault. And it starts at memory stick number 3767.
It's not only I who am grateful for these page references, those sitting behind us are also.
I know you need them, it's just I sometimes forget. I won't spend time reading it. If the court reads, first of all, what happened in Nare in the fullness of time, what actually happened was that there was a telephone link. Evidence was given over the telephone link. The Home Office representative refused to cross-examine because the identity of the witness couldn't be guaranteed. The tribunal decided the case in the appellant's favour on the basis of the evidence given over the telephone. The Secretary of State appealed. The tribunal held that the Secretary of State couldn't complain because he hadn't cross-examined, but then said the tribunal was wrong to receive the evidence over the telephone in the first place. And the final point on Nare is that if one goes on to paragraph 18, immediately above the guidance, the Nare guidance is designed to deal with, to use the words of the last sentence of paragraph 18, anything that's happening that's require guarantees that anything that's happening off camera, by which it means off visual contact or telephone link.
It was that led me to ask the questions that I did of Lord Keane in the context of criminal evidence.
Yes. Well, what we end up, I'll take this very quickly. What we end up with is a set of rigorous formal guarantees about being sure about the identity of the witness, be it Skype, or be it video link, or be it telephone, none of which are routinely capable of being satisfied at the moment in this type of appeal. So we come back to my submission that whatever be the theoretical position about how 94B could be complied with in a different world. In the present world, the machinery simply isn't there to enable it to work fairly. Limited number of other points, which I can make in a couple of minutes.
You better be quick because you're already past your time.
Right, okay. Georgiou, my learned friend says, is irrelevant. The point about Georgiou is paragraph 22, Roman 4, not about the EEA test of present threat. It's simply about the difficulty of evaluating risk without seeing the witness. And 22.4 goes straight to that point. Secondly, Pinnock and Article 6. It's important to remember that Pinnock is an Article 8 case. It's not an Article 6 case. It is itself about the procedural requirements of Pinnock, of Article 8. Obviously, requirements of Pinnock too. Whatever be the position as to fact-finding, it is in my submission crystal clear that the test in this sort of context for whether there will be a breach of Section 6 is proportionality assessed by the court, not Wednesbury with anxious scrutiny. Wednesbury with anxious scrutiny is a feature stemming from Turgot and MOD and Smith, overtaken by, first of all, Smith in the UK in Strasbourg, and then by the enactment of the Human Rights Act. So one is simply, straightforwardly, dealing with proportionality. There's no need at all to go through the spectrum of the pre-HRA cases, such as Turgot and anxious scrutiny. Well, my lady, those are my submissions. I'm sorry if I've gone over time, but there we are.
Only a little bit. Thank you, Mr. Drabble. Mr. Gill.
My lady, this morning I had put before the court a short list of page references to cases. That was simply because yesterday, on the question of the test to be applied, I didn't have time to give those references. I don't say any more about that now, save simply to remind you that on the approach as to the role of the court, those submissions are set out in paragraphs 84 following of our printed case. We say that Kiarie is incorrect so far as it, or rather, let me put it this way, the Kiarie approach cannot be applied in this human rights context approach. The relevance of Section 6 of the Human Rights Act point, that is the court that decides for itself, is set out clearly at paragraph 86 of our printed case. The one other point in relation to this that was raised just whilst I'm on the printed case is that none of the evidence, there was no evidence from the Ministry of Justice at all in the court below. As we made that point to the lower court, that is set out in our printed case at paragraphs 146A at MS 6708. So far as the test is concerned and the error in focusing upon real risk of serious irreversible harm, it was in effect conceded at the hearing itself. The correction then occurred, as you've heard, on the 30th of October, which is why we put before you version 5 of the guidance. For completeness, we've given you version 6. Version 7 is in the bundle, and I've taken you to that. But when you look at that, we say the message to caseworkers is still to drive home the point about the importance of real risk of serious irreversible harm. I'm not going to take you to the relevant passages in version 5 at the moment, but simply invite you to look in version 5 at paragraphs 1.4, 3.2b, and 3.18 for the emphasis and the impact it has on the minds of people who are not highly trained. I don't say that with any disrespect, but there are people who are not lawyers. And the impression that is given is that serious irreversible harm still is a
Which
a
were the
significant
paragraphs?
matter.
1.4.
1.4, 3.2b, 3.18 for this type of examples in particular.
Okay.
And then you don't really need to look at version 6. Version 7 I've already taken you to. So that's the point on whether they've corrected it. We say they haven't, which is why you're still getting, even after that, all these cases of decisions being made on Section 94B against persons and the statistics that you've got. That's in relation to the tests. As to the agreed procedure in the tribunal, you will have seen that there was a direction only in relation to that in the permission hearing appendix, and a note was prepared to the extent that it could be agreed, and you've already been shown that note, appendix 2, page 395, MS 7261, and you see what it says there about video links at paragraph 18. It's agreed there's no provision for payment, and the payment burdens fall upon the appellant. As regards then more substantially as to the points about the need for oral evidence, in relation to that, we have set out in our printed case the arguments about the public interest and how the public interest in relation to the Hesham Ali case doesn't entirely feed through. It may be relevant as a backcloth, but that is not the public interest that is relevant in the present case. What is sought to be being done in the submissions that you heard from the respondent today was to not focus upon the risk of present threat, but to really make everything subservient to the overriding aim, which appears now to be the deterrent effect. Because they need to send out a message, they say, to foreign criminals of a certain sort, then it follows that the full weight of the policy behind Section 32 must feed into Section 94B. We say that that's not correct, because nothing in Hesham Ali, in fact, says anything other than that. Whilst there is, of course, a great weight to be attached to the public interest in deporting foreign criminals, you still have to comply with the Strasbourg case law. Hesham Ali, the references to that are in our printed case at paragraph 93, which is on MS 6695 over the page to 6696, and in our printed case at paragraph 110, MS 6700. And the footnote to that is relevant for the passages from Lord Wilson's judgment and from Lord Carr's judgment. Lord Carr set out the relevant Strasbourg cases. Nobody else did. He set out the Strasbourg cases. I don't apprehend the majority disagreed with those, that was the cases. They just took a different view on the basis that because of the margin of appreciation, the state could, through that, place a great weight on the public interest in deportation. So be it. But that doesn't mean that any of that analysis of the actual cases from Strasbourg that come in Lord Carr's judgment are in any sense dissented from by the majority at all. It's perfectly ordinary analysis. And therefore, one thing that one has to bear in mind is this, especially when one considers the Giorgio case, which was at volume 11, tab 137 at MS 3913. That was a case which related to the EEA regulations, where, and those regulations that are at volume 1, tab 22, MS 303, and regulation 24AA is the material one. It's couched in exactly the same terms, in all material senses, the same terms, as Section 94B. Now, it was sought to be said by Lord Keane that that is about present threat considerations, whereas in the Strasbourg context, I think he would say that the idea of the present threat of the person in this country has I paraphrase, he may not put it this way, has less importance. I say that's wrong. Whilst I acknowledge that in the EU law context, the cases on deportation are very, very much focused upon is there a real present threat of the individual. In a Strasbourg context too, that is the case. True it is that in a Strasbourg context, there's a little bit more margin of appreciation to bring in this point about the public interest and how a state may choose to apply the public. But the difference is not that great. And so when what is sought to be done is to say that because there is need to send out this deterrent message, we therefore must carry through the Section 32 policy into Section 94B. We say that is fundamentally wrong and contrary to Section 6 of the Human Rights Act, which appears both in Regulation 24AA as well as in Section 94B. So once one has that point clear, and one then ties it up to the point that Lord Wilson was making to Lord Dean, that in fact when one gets to procedural rights also, one has to show a greater restraint, knowing that the public interest in ultimate deportation will in fact be protected in any event by what happens at the full appeal. We say the respondent's argument on the public interest pales away. And in the context of providing out-of-country rights of appeal, you have to ensure that everything is done in a manner which is compliant with Section 6. So the need for oral evidence, therefore, we say in this sort of case is very, very real for all the reasons that I referred to earlier, which I won't take time repeating. As regards some practical points, at Appendix 3, Internal 545, MS 7411, there is evidence of the practical problems that arise. The time differences between some countries and the United Kingdom is important. There's evidence there which says one would have to get up at 4 a.m., travel halfway across the country, well, a long distance anyway, get to a centre which is a centre which has the relevant facilities, secure facilities of a type acceptable to the Ministry of Justice, and you may have to travel overnight. Now, this is simply impossible for people in many parts of the world. So there are those sort of practical problems. In terms of the listing problems, you heard some evidence which emerged orally that apparently there is 20-week waiting period from the notice of appeal from the receiving of the notice of appeal by the tribunal to the listing of appeals. And that's apparently today. Well, I've not seen the source of that. I'm not sure whether that is in fact right, and I don't know whether that 20 weeks is in fact from the point at which the tribunal get round to dealing with the notice and dealing with the notice of appeal and actually setting a hearing date. We don't know on what basis these statistics are made. Maybe the 20 weeks runs from the point that the hearing date is actually fixed. So I don't know how the figures are logged. But more importantly than that, don't have time to take you to it, but can I ask you, and this is really important that you do look at this, MS 6171, the 72 weeks. So I'm not wrong about the 12 months. You'll have to go through those statistics there.
What was that reference?
MS 6171.
Where do we find that? Which volume?
6171 is on... No, which volume of the appendices? It's volume 18, tab 205, MS 6171. There's a table there of out-of-country appeals, and you see on the right, true, 72 is one of the higher figures there, but there is other figures, about 48 weeks and so on. And so, and moreover, so that's what's gone into the authorities' bundles. Moreover, the statement of facts and issues itself, at paragraph 11, talks about 38 weeks. Those are the agreed facts. It may be that some other statistics have emerged recently which talk about 20 weeks, but I don't know on what basis they
Now,
they
6171, very quickly, what is the line of the schedule that you would have us highlight?
It was the column on the top left of the page, from what I recall, on the right-hand side.
Which line, though? Is it asylum protection? Because entry clearance officer and family visit visa have nothing to do with these circumstances. And they're the 72-week ones that you were referring to.
No, you'll see that it says...
Human rights.
Yeah. There are asylum protection, managed migration, entry clearance officer. It'll be...
It won't be that.
Well, family visit, human rights, 35.
Yes. So is it the human rights one you're wanting to refer us to, or is it another one?
49. Now...
What is it you're wanting to refer us to? Other includes deportation and deprivation of citizenship appeals, if you look at the footnote on the following page. So perhaps it's other that you're wanting to refer to.
Yes.
It may be other, but 49 weeks, and bear in mind well, yes, but it is a significant period of time.
Yeah.
And that's the average, and you see what the other figures also. Yeah. The entry clearance cases are, of course, out-of-country cases, and there is no great imperative, it seems, to list them quickly. As the respondent's own evidence suggests that the listing of in-country cases of detained cases is done as a priority. I've given you the reference to the Statement of Facts and Issues at paragraph 11, which I think is at MS 6560, which the agreed facts are 38 weeks. But there are, therefore, very, very significant delay. Further on listing, can I, and the problems that can arise in this regard, can I just leave two other references with you? Mr. Sharma's third witness statement, volume 3, internal 522, MS 7418, paragraph 14, and Mr. Giles, Kiarie's solicitor, at volume 3, internal 784, MS 7650, at paragraphs 10 to 12. Can I then move on to say something about the facts and the documentation? You were shown the letter of the, you were shown the questionnaire, which was of the summer of 2013, and that's in volume 5 at internal 1328 MS 8194. You will recall the information, the material that I took you to in opening, where Mr. Byndloss said he needed help he wrote that handwritten letter saying he needed help with this. So one of the ladies took it to a solicitor, and his handwritten letter saying he needed help is in the bundle I took you to it in opening. Now that is why on the 4th of October 2013, Mr. Sharma, with 30 minutes pro bono help, no legal aid, did what he could to fill out that material, pro bono, and that is 7351, and he says in his third witness statement at paragraph 9, 40, and 41. Can I ask you to, just for your note, look at Appendix 3, Internal 551, MS 7417, and MS 7426 and 7427. He describes the circumstances in which he had to fill out that form. Now, none of that, so that's, to the extent that he's a solicitor, that's the extent to which he's a solicitor, a drop-in service for the local public, pro bono clinic type help. It's still up to the Secretary of State then to actually carry out inquiries. For them to say that there's been 2 years is simply inappropriate for this reason. At that time, in summer of 2013, it would not have mattered to the question of the right of appeal if Mr. Byndloss had done nothing to return this questionnaire. The reason being, he had a right of appeal, in-country right of appeal. It wouldn't have mattered if it was half filled in or not filled in or not returned at all. It would, moreover, the questionnaire did not ask him to make representations on why a Section 94B certificate should or should not be made, precisely because it was known that he had a right of appeal anyway in country. It was not until the 2014 Act kicked in that they needed to do something else about putting forward a questionnaire, and they never did. He was never invited subsequently to provide, at any point, to provide information on why a Section 94B certificate should be done. That is why the Court of Appeal upheld the challenge in relation to the 6th of October 2014 letter. That is why this point that we've had 2 years is completely a bad point. When the law begins to, nevertheless, Mr. Byndloss is concerned. He writes letters, as we've seen, in June, July, August 2014. Not all of them have been disclosed because they presumably lost it just as they failed to look at the material of the 27th of October 2014 pre-action protocol letter. But we do have one of those letters from July 2014 that I took you to in opening, paragraph 8b of our printed case. And material was put forward in relation to it. It's that summer that the law begins to change. 28th of July 2014 Act comes in. And then what happens is that they then just make a decision on the 6th of October. And we say, even on the material, which is why it's really important for you to follow through the material chronologically. I'm sorry, it's not in that order in the bundle. Even on the material as before them, at 6th of October 2014, they could not have concluded that there was no genuine or subsisting relationship with a child. In fact, they did not conclude that. They assert at various points later, but if we look at and I do want to show you this, in the core volume, Statement of Facts and Issues at 6567.
Paragraph?
Paragraph 36, bottom of MS 6567, refers to 6th of October 2014, says the Secretary of State concluded that although B had a genuine subsisting relationship with at least one of his children, he did not meet the requirements of our 39939AA. So they finally accepted this in the SFI. Not in the 3rd of September letter, which paints an incorrect picture. And therefore, we say that given that they had accepted in the letter of 6th of October 2014, there was, if they don't like the phrase family life, or they think their rules require more than that, fine, let's just stick to genuine and subsisting relationship. They themselves accepted that it was genuine and subsisting relationship. That being the case, on 6th of October 2014, they could not lawfully, according to version 1 of the guidance, that trial period that was there, the rollout period, they could not lawfully have issued a Section 94B certificate. What should have happened is, they should have given the letter setting out the Section 32 decision and said, here's your right of appeal, now lodge, now you've got 14 days or whatever it is to file the notice of appeal with the tribunal. They cannot now be heard to say, by relying on a subsequent letter in 3rd of September 2014, which they call a supplementary letter, and use it as a forensic weapon in a way castigated by Lord Justice Beatson in Karupan, they cannot be heard to say by reference to that letter, somehow you should be denied the remedy which you would have had, the rights which you would have had on 6th of October 2014. If the whole point of the rollout period was that those who had a genuine and subsisting relationship with a child should not be subject to Section 94B, at least until during that rollout period. Then we had a right of appeal. That should have been the end of this case on the facts. But no, we then, they issued a Section 94B certificate. We had to challenge it. And as you've seen, it's now accepted that on the 27th of October 2014, we filed quite a lot more material. And bear in mind that at these stages, there is no legal aid. Emergency legal aid simply to lodge a JR application form, a JR claim form rather, but nothing more than that. When it is said that there's 2 years, you have to bear in mind the really practical difficulties that public funding creates in this context. It's emergency funding is one thing, but it's really only at a later point in time that one begins to get fuller certificates sometime in, I think, around about February 2015 or early 2015 anyway. And even then, pre-permission, it's really difficult to persuade the LAA to arrange other types of funding for things like independent social worker reports. And in any event, why should we? We filed on the 5th of November a claim form attacking the 6th of October decision on the evidence as it then stood. On 6th, even as at 6th of October, we say we were entitled to succeed on the evidence as it stood. As at 5th of November 2014, we say we were also entitled to succeed on the basis that the court needed to look at the evidence as it stood then. You heard Mr. Fordham's submissions on that. So why should we have needed to do anything further? We did not know that the other side were actually going to carry out a review of the material that we submitted at that point. They did not say to us, we are going to carry out a review. They say that we were waiting for further material from us. Well, that is misleading, because if that is the position, it would have been the simplest thing in the world for them to say, Mr. Sharma, Mr. Byndloss, we note that in 2013 you sent a questionnaire, partially completed questionnaire. A lot of time has flowed since then, 18 months or so. We know that there are children here. We have a duty under Section 55, etc., to take the children's best interest into account as a primary consideration. We're concerned about this. Is there anything further you have to add? Because now we want to make a decision. The reason why they didn't want to make a decision is because permission had been refused in the High Court. It was only after permission was granted in the Court of Appeal that they thought, hold on, we better do something about this. And even then, they did not bother actually saying to us, straight after that grant of permission, before the summer break, we're now going to make a new decision. They waited until Bank Holiday weekend, having forced the Court of Appeal to shorten the timetables. Which is why it's really important that you look at all the documents with some care. That is why, when in Karupan, Lord Beatson says, these supplementary letters are used to put the claimant at a disadvantage. Para 95, let me just take you to certain parts of it. As forensic weapons, this is the point that he's making. This is the mischief he's getting at. It's volume 10, authorities bundle at tab 117, and the MS number, sorry, I had it loose, is 3542 is where it starts, but, sorry? The main paragraph start at paragraph 90, and that is at page 3575. And you see at the end of paragraph 90, it says, supplementary letters potentially has real disadvantage to claimants and should only be permitted where it's absolutely necessary that those disadvantages do not arise. At paragraph 95 on 3576, he talks further about retrospective rationalization. And the Secretary of State's approach as a measure of wanting to have one's cake and eating it. He talks at paragraph 19.9 at the end on page 3577, saying the practice of holding back supplementary letters treats them as weapons in a forensic battle. That's precisely what they did here. They held it back. Those points, I just want to make sure I don't breach time in relation to this, we say, then put us in the position where we, and you'll recall the correspondence that I took you to in volume 5 on this, where we had to produce material. Lord Keane said, they would not know when the material would emerge. I say that is misleading. They had no reason to think that we were going to put forward material. The case was to be fought on the evidence before the Court of Appeal at that point, and we would have won on that material. So in any event, when you look at the IS Independent Social Workers report, he says, which is in volume 3, internal 611 MS 7477, he says, there has been unavoidable delay in completing this report following receipt of the Secretary of State's supplementary letter. In other words, because the letter was sent, he's having to rewrite whatever he was working on. And he's having to go back and see the children again. The further evidence in Mr. Sharma's witness statements makes that point also. In this same document, what this independent social worker talks about is at internal 626. I'll give you the MS 7492, some of the difficulties that arise when people are in prison, difficulties for children at 630 and 641. There's further material on this, but I don't think I've got time to read it out, but I invite you to look at it.
You're just about up to your time limit, Mr.
Yes,
Gill.
yes. So on 641 and 642, there's MS 75077508 is material about how about the situation when a parent is in prison. Lastly, then, can I just make two final points? One is in relation to Skype. We all talk about Skype, but does anybody actually understand the dangers with using it? Has anybody actually considered the data protection issues, the data retention issues, on which servers are these materials stored? Nobody has, because nobody really understands it. That's the problem. And one of the problems, I was just Googling as we were hearing this, there are concerns on the internet about the privacy issues in relation to Skype. Not difficult to find, but in any event, there are real difficulties. You need secure systems, and at the moment, no systems exist whatsoever. No rule changes have been made to allow entry clearance officers to allow re-entry. So on the face of it, there will be a refusal. And the last point is this. You'll have seen that at Authorities Volume 2, Tab 30, at MS 585, you were taken to a document, a policy document on the Home Office. Well, can I invite you to look at 3.3.2 and paragraph 3.5 in there? Because that talks about unduly harsh. And the reason why this is relevant is this, that the best interests analysis that is conducted in the 3rd of September 2015 letter is all conducted through the filter of the immigration rules. Now, on the assumption that that was a complete code, which Hashim Ali tells us, well, it isn't a complete code. And in FM Nigeria, the Court of Appeal were wrong to characterize it in that way. And the point about unduly harsh is, that phrase appears in those rules 399A and thereabouts, is that it is on no basis a reflection of the best interests duty. It comes no close to dealing with Article 3 and Article 12 of the UNCRC. The only way you can make those rules work in a manner compatible with Article 8 is if at the end of para 398, that bit about very compelling circumstances, is read in a manner which is consistent with a best interests analysis. Third of Mballetta does not do that at all. It does not recognize that that phrase unduly harsh, whether the children could live here without the father in a situation where it's not unduly harsh, that has to be looked at in a best interests way. Rules don't do that unless you make the end of para 398 work in a manner which is compatible with everything we've put in our case about best interests. Lady, those are my submissions.
Thank you very much, Mr. Gill.
My lady, I wonder if I could have permission to give you 2 references, please.
I think so.
Thank you.
Yes.
The first is Lord Wilson in H, the extradition case. It's paragraph 151, and it's at page 2134, volume 6, tab 70. And the phrase is, the overarching obligation of the court under Section 6 of the Human Rights Act. And the relevance of that is because you've heard some submissions about whether Section 94B makes the Secretary of State the decision maker and takes it away from the court. And the second reference, and this is on the question of primary facts when the court is discharging its Section 6 obligations, is a phrase of Lord Bingham's in Huang. The reference is at page 1200. It's Authorities Volume 4 at tab 49, and it's at letter F on that page. And Lord Bingham explained that when the court is discharging the Section 6 Human Rights Act obligation and deciding facts and looking at up-to-date evidence, the phrase is this: it can accord appropriate weight to the judgment of a person with responsibility for a given subject matter and access to special sources of knowledge and advice. So yes, of course, facts can be left undisturbed by a court applying Section 6 if it decides that it's appropriate to give them weight for that reason, and I accept that. I hope those are helpful references to the court.
I better ask Lord Keane if he wants to come back on that.
I'm most obliged, my lady. Could I come back without indulging in ping-pong by simply drawing attention to the Carlisle case, which is at tab 76, and in particular, Lord Sumption's observations at paragraph 31, MS 2445, where he says, none of this means that in human rights cases a court of review is entitled to substitute its own decision for that of the constitutional decision maker, however intense or exacting the standard of review in cases where convention rights are engaged. It stops short of transferring the effective decision-making power to the courts. I'm most obliged.
Well, of course, you will be aware that the rest of the court didn't agree with Lord Sumption on that point.
Well, I just draw attention to that observation and also to my lady's analysis at the end of the case as well. I'm not going to go into it in detail, but underlying the point is the point made by Lord Sumption.
We will refresh our memories appropriately, no doubt. We are most grateful to you all for your written and oral submissions and for the amount of work that's been done on this case from a number of quarters. We don't underestimate the importance of the issues that are at stake here. We will let you know our decision as soon as we can. Court is now adjourned.